I have instruction from my client to withdraw.
4.
Item 4.
Okay. All sides are represented. Upon instructions, the learned counsel for the petitioner seeks to withdraw this writ petition. Prayer is allowed. Matter is dismissed on withdrawal.
Bishop, I also beg to mention item number 31. And this must be submitted. Taken up next week.
31.
My lord.
Also
Next week, what is?
next week. Okay.
My lord.
What says the representative of the prayer made by learned counsel for the petitioner list in the next week?
My lord.
Okay.
Launch of Bishop.
In item number 4, record his name, say Gauhati.
May I please? Lordship, I beg to mention item number 28. If this matter can be listed after a week, my lord, I have taken the consent from the other side, my lord.
Okay. What says the same order? What says the representative of the prayer made by the learned government to get the list on
After a week, my lord.
list or after a week? Okay.
Deeply obliged.
Lordship, I beg to mention item number 5 and 6.
5 and 6.
And for the petitioners and where you to file an error. So if 2 weeks time can be granted for us to file an error.
You want to file?
Sorry.
You want to file what?
Affidavit in reply.
Okay. 5 and 6. All sides are represented. On the prayer made by the counsel for the petitioner, the matter stands adjourned today to enable the petitioners to file affidavit in reply in the matter. List after 2 weeks.
Lordship. Obliged.
Yes.
Lordship, I beg to mention item number 27. I received your affidavit in opposition just now inside the court. So allow, and I'm informed that the NSSB, they have not been represented till date. Although we have send notice through registry, Lordship,
NSS,
and
means-
SSB,
what is that full form?
Nagaland State
Selection Board, okay,
Yes.
okay.
Nagaland Staff Selection.
Staff Selection Board, okay.
Just 1 week may be given, then we will serve it through Dusty, Lordship.
No, not required. Once you have served, it is complete. Why do you have to bring them? They are giving you a walkover, you have a good reputation.
They are respondent number.
No, I understand, but perhaps knowing your reputation, they want to give you a walkover.
Maybe, Lordship.
Hmm.
If in positive way, that's well and okay, because it is they who has to advertise. And I haven't gone through the documents, but I'm told that they have already
Once
sent
it is served, we are not issuing fresh notices. Unnecessarily, we don't issue notices again.
requisition.
If it is served, if
So-
they don't appear, they take their responsibility of their action.
Yes, Lordship.
Okay.
That in that matter, allow me to go through this and allow me to file counter affidavit, if any. A week time may be given because it's
Okay.
immediate disposal.
Both sides are represented. Ms. Zertibhomi, the learned counsel for the petitioner, has submitted that till date, the Nagaland Staff Selection Board has not entered appearance. All the notice is served. First of the said submission is noted. Next paragraph. She prays for a week's time to go through the affidavit in opposition, which is served on her by the state only today, and to take instructions and to file a reply if so advised. So matters stands adjourned today. List after.
Next week, Lordship, give a fixed date.
Okay. When do you want?
No. Maybe on 23.
Okay, list on 23. 9/20/25. Okay.
God bless. Lordship.
Very pleasant, Lordship. Lordship, I beg to mention item number 11. Lordship, if I may be granted another 3 weeks time to file my affidavit, Lordship.
Okay. Which is represented on the prayer made by a government advocate. List after 3 weeks to enable to file affidavit in opposition in the matter.
Lordship, similar prayer with item number 12 and 13, Lordship.
12 and 13.
Lordship.
Okay.
14 also, Lordship. 14.
Okay, same order. But this 12, 13, and 14 pass separately, yeah? Separate orders. Okay.
Lordship, I also like to beg to mention hearing item number 29.
29.
Lordship, 29. Lordship, can you pass over for a day? I have taken the consent of the petitioner, Lordship.
Okay, same order. List after a week.
Lordship, pass over for a day, Lordship. Tomorrow, Lordship.
No, it will be Monday then, because tomorrow will be
Lordship, on Tuesday.
Tuesday. Okay. It says it on the prayer made by a government advocate. The matter stands adjourned today. List on Tuesday next will be 10th. Oh, sorry, 16th.
Lordship,
Okay.
I pleasure.
Please, Your Lordship. I beg to mention hearing item 13 on behalf of Ms. Singh and Montgomery.
13, 1, 3,
13.
3, 0.
Lordship, can this matter be fixed on Tuesday?
You're for the petitioner.
Yes, Your Lordship.
Okay. What says it present on the prayer made by and cause of the petitioner list on 19/8, 19, sorry, 16/8, 16/9, I'm sorry. Ah,
It's Lordship. Lordship, I beg to mention item number 9 and 10, Lordship. I have some personal difficulties today, Lordship. If the matter can come up on Thursday, I've taken the concern of the state respondent, Lordship.
okay, 9 and 10.
9 and 10, Lordship, please.
Okay, 9 and 10, it goes to 18th September.
Yes.
Okay.
The plea of Lordship.
The prayer made by and counsel for the petitioner. Okay.
Obliged.
Okay, so Lordship, I beg to mention here in item number 31. Lordship, may kindly list this matter after 2 weeks, Lordship.
21. Okay. Both sides are represented on the prayer made by and counsel for the petitioner list after a week.
Please, my lord. I beg to mention item 16. May I pray that 3 weeks time may be granted.
16:16.
Yes, ma'am. 16.
Okay, after a week on the prayer made by and counsel for the petitioner. Okay.
Much obliged.
May I please, Lordship? My lord, I beg to mention item number 35. Kindly list the matter on 16 months. I've taken consent from the opposite party.
Please, Lordship.
35. Okay.
Yeah, please, Lordship. Lordship, I'm praying for little indulgence in this case. Well, there is an urgency in the matter. This is the third round of litigation. The petitioner was declared successful in the Nagaland Public Service Commission for the post of sectional assistant. But then there was a complaint against the genuineness of her indigenous certificate. Accordingly, Lordship, the inquiry was conducted and indigenous certificate was cancelled. That is the issue. So we, and in that view of the matter, her appointment is also suspended. So may I pray that on 16th, let this be listed as first item for disposal because there's public interest.
We will not say first item in the board, but
Lordship,
you make a prayer, it can be upgraded.
Lordship, yes. So as a fixed item.
Both sides, including Mr. Tagamasel and the senior counsel, is for the appellant, petitioner is present on the prayer made by the government advocate. List the matter on
16.
16/9/2025.
Obliged.
Much obliged.
May I please, your lordship? Lordship, item number 15, kindly grant me 3 weeks of time since I'm yet to receive instruction, lordship. Item number 15.
Which department? Which department is to give you instructions?
Lordship, I'm on behalf of Mosam. Mosam, he is out of station.
No, which department is to give you instructions? Which department?
Education department, lordship.
Education. Okay.
Lordship,
Which
this
is
is
represented on the prayer made by the government advocate. Yeah, you just say both sides are represented. The government advocate has submitted that the education department has not yet furnished him instructions. First off, the learned government advocate shall send the downloaded copy of this order to the concerned authorities in the education department so as to ensure that instructions are sent within 2 weeks. On the next date of listing, the learned government advocate shall inform the court as to whether the order of the court was sent to the respondent authorities and produce a proof thereof before the court. List after 2 weeks.
Lordship, there is an interim.
Okay, interim order past list has extended till the next date of listing.
I know, Lordship.
So send the order copy and next date you have to show us
Lordship,
where you have sent.
Lordship, my apologies, is item number 32, which I've mentioned, it's not 31. Nicholas Lee Scanner.
You paid for 31.
Yes. It's
30.
3, not
Okay,
31.
not 30. No, 31 was made, prayer was made by Mr. Yangarwati.
Item number 33, it's item number 33.
33.
Yes, Lordship. Hearing item number 33.
33.
Yes, Lordship.
Okay. We had passed an order in 31.
Yes, yes.
Okay, not in 31, in 33. Okay.
May I please, Your Lordship?
Just tell the courtmaster just inform the courtmaster so that he's got it.
Your Lordship, I beg to mention items 17 to 25. Your Lordship, here the state is yet to file affidavit. So, Lordship, may kindly grant 3 weeks' time to obtain instruction and to file affidavit. Here, the counsel for the opposite party has no objection for adjournment, and if the matter can be listed after 3 weeks, they have given the consent.
Okay. This is a representative of the prayer made by ungovernmental way. Is the matter up to 3 weeks so as to enable the state to file an affidavit in opposition in the matter.
I'm obliged.
17 to
17 to 25.
25.
Obliged.
Yes.
This Lordship. By the commission, I beg to
32. I'm almost unemployed.
Lordship, I'm not a chair.
No, it's okay. No, it's okay. Nothing against the adjournment, but I'm just telling you, I'm gradually becoming unemployed. 32. Both sides are represented. The prayer made by unconstitutional the petitioner. List after 2 weeks. Okay.
President,
Okay. Interim order passed release stands extended till the next date of listing.
And please, Lordship. So kindly allow me to mention item number 38, motion item. Lordship, here the principle.
Item number?
Lordship,
Item number
38.
38.
Lordship, here the principal council has some responsibility. If this matter can kindly be brought forward to the day.
Okay.
May it be listed again tomorrow or Monday?
No, not tomorrow, Monday.
Monday, Lordship.
The prayer made by both sides are represented. The prayer made by unconstitutional petitioner. List on Monday. 15/9.
May I please, my lord. My lord, I beg to mention item number 1. Here, my lord, I'm appearing for respondent number 5. My lord, we are yet to file our affidavit in the position.
Just a moment here. Give this item number 1. Item number 1, it's adjourned a lot of time. Who is the authority to give you instructions?
We are yet to receive some document.
Who is the authority to give you instructions?
Private
This is the private respondent, my lord.
Private respondent, then we want to adjourn it. Because we have given a lot of adjournments. You see, this is the amount of orders we have passed for adjournment. Not one. I can't even count. No,
My lord, I pray that another opportunity may be given.
take it up on Monday. We no adjournment.
1 week, my lord.
Lordship, I'm here to file my reply to the respondent.
Don't file. You see, he has not filed your an affidavit. You have to respond to the government affidavit. What is stopping you from doing it?
No, I've just received recently.
Okay. All sides are represented. The learned counsel for the private respondent has prayed for adjournment. Similar prayer has been made by learned counsel for the petitioner to enable her to file an affidavit in reply in the matter. The same shall be done within a week. List on listing it next Thursday. 18.
Mazulas.
Lordship, I beg to mention item 2 and 3. Affidavit is ready and we have sent it to obtain signature, so kindly give us a week to file.
2 and 3. Okay. This is a representative of the prayer made by learned counsel of the petitioner. Just after a week to enable her to file affidavit in reply in the matter. Okay.
I'm waiting for AG. Principal Accountant Office. In fact, the dispute is between the petitioner and government.
No, we have said all sides are represented.
That's.
Make it all sides, huh? All sides are represented.
Oblige.
Yes. Yes, Mr. Chaudhary, you are the only odd man out for not making a prayer for adjournment. All matters except last 2 items, last 4 items are adjourned. Yes.
From the supplementary cost list, for motion, item number 36.
May I please, Lordship?
Yes.
Your Lordship, the petitioner was initially appointed as monthly on road basis in scale pay for a period of 1 year. Your Lordship may see page 16, annexure A.
You have already superannuated.
Yes, Your Lordship. She
No,
was,
why?
after serving for 24 years, she was released from service without any pensionary benefits, Your Lordship.
But after retirement, how can we regularize your service? It's already gone. You did not appear on, did not do the needful on time.
Your Lordship, the petitioner case hearing is covered by the principle of law laid down by the Honorable Apex Court as well as by this Honorable Court, Your Lordship.
Which one? Which case you are referring to?
2019, then SCC 516.
2002,
2019,
19.
yes, Your Lordship. Then SCC 516.
This is a book, code book.
Paragraph 36, Your Lordship.
No, in your case, first you'll have to, you have the book SCC. In this case, come to paragraph 8. Does it start with we first consider?
Yes, Your Lordship.
Yes, please read that paragraph.
We first consider the provisions contained in the Uttar Pradesh Retirement Benefits Rules 1961. For short, the 1961 rules. Rule 38 of the 1961 rules, which contains the provisions in respect of qualifying service, is extracted here under.
So paramateria is provision of law is not there in your state.
Your Lordship, I'm referring to para 36.
No. You see, I have a very bad habit. I start from paragraph 1. By the time I reach paragraph 36, there are many paragraphs in between. So out of this, I just refer to only one paragraph. We are yet to come between 8 to 36. It's a bad habit. I can't shake it off. You see, you're a young lawyer. I must tell you one thing. Please don't take it that I am sermoning. Correct? It's just for your benefit. You see, a judgment is read not as a law book, not as a what you call a act or a rule. It decides only on the facts of that case. So unless these facts do not match to the present fact situation of your case, how will it apply? That would be the second question.
Yes, Your Lordship.
So you see that reading of one paragraph or two paragraphs would not help you. I'm just saying it for your benefit.
Yes,
Don't
Your
take it that I am what you call summoning you. I'm not shaming you. Correct. It's just for your growth. Once you adopt that policy, you will never look back.
Yes, Your Lord.
Correct. If this, because you see, your case would be hit by Uma Devi 3, as what you call clarified by the judgment of ML Kesari. This is an exception to the rule because of the fact that under 3, the Supreme Court, this is a full bench judgment which the Supreme Court was considering. Then come to paragraph 9. Because this you see, when after this Uma Devi came, they had this rule, regulation 361, 368, 370. Now come to 361. The services of an employee who does not qualify for pension unless it conforms to the following 3 conditions. So these conditions are laid down. 368. Service does not qualify unless the officer holds a substantive office on a permanent establishment. 370. Continuous temporary official service under the government of Uttar Pradesh following without interruption by confirmation of the same by any post except periods of temporary officiating service in non-pensionable establishment. So everywhere you are ousted. So this para 36 would not help you.
Your Lordship, I have another citation. 1997 to GLT 209. 1997.
Yes. You know, this judgment also doesn't help you of the division bench of this court. You know the reason. Can you think of a reason why a single bench is saying that this division bench order may not be applicable? Can you think of a good reason? No. The reason is after Uma Devi, this amounts to prospective overruling. When the Supreme Court has laid down a law, then anything contrary which is there in the any other judgment of any other court prior to that would be hit by the law laid down by the Supreme Court of India, because that is saved. Supreme Court judgment is saved under Article 142. 141, sorry, 141. That will always have overriding effect. If we give you a chance, we take it up tomorrow.
Your Lordship, at this stage, notice may.
No. We are giving an opposite till tomorrow.
Lordship, I'm going to petition here. Lordship, the case of the petitioner for regularization, post-regularization of the retirement has been denied by the respondent of police by issuing a letter in the month of June this year, on the ground that the case for regularization of the petitioner doesn't come under the OM of 2015, which provides for regularization of work charge and visual employees who have completed 30 years. Unfortunately, Lordship, although petitioner was continuously serving for 24 years and was injuring his LP, he was released from service on Superannuation after serving for 24 years. So, Lordship, I bring for regularization of her service solely for the purpose of pension. I know Lordship knows and enough decision, this Honorable Court as well as the Supreme Court held that releasing a person after serving for 2 to 3 decades without pensionary benefits with empty-handed is in violation of Article 16. So on that ground, I have approached this Honorable Court by way of this petition. The law has been laid down in Dharam Singh case also, but then since it is in motion stage, I'm not referring to all this judgment, Lordship. So at this stage, my humble prayer is, Lordship, this will be issued and let the government file the affidavit whether I'm entitled for regularization for pensionary benefit, Lordship.
No, but you'll have to overcome this, what do you call, the principles laid down in the case of Uma Devi 3, as clarified by ML Kesri. It says it can't be a continuous exercise. How do we negate that? In this state, has the state adopted a policy of giving a pension? Because you see, for the purpose of paying pension, there must be a contribution from the employee. So if that is not enforced, how will we? Let us see that. Let us assume that we have issued notice and we are hearing the matter. How can a pension be ordered if there is no contribution at all? If he was in service, we could have used this Upen Das and said that you give them a fixed pay. Or sorry, not fixed pay, it's called skill pay.
She was injuring skill pay, although she was on work just basis, Lordship.
Then nothing more can be done.
And she continued in service for 24 years, Lordship. And Lordship, there is a memorandum of 2004, which
Because you see, pension can be or directed to the state only when it is a pensionable service. It must conform to the pension code.
The petitioner was serving under the pensionable establishment.
No, establishment may be pensionable, but the service was not.
Lordship, notice will be issued at the time of hearing also is by Lordship.
No, you see, we also follow that principle of issuance of futile writ. That's why.
Otherwise, today I'm not prepared with all this judgment, Lordship.
Take it up tomorrow. We'll take it up tomorrow. We are giving your SSD council a chance. Let her be prepared for tomorrow.
Next week, Lordship.
Next week. Okay. Both sides are represented.
For motion,
on the query of the court as to how the petitioner would be entitled to claim pension after being already discharged from service as a work charge employee with effect from
for regularization of my service.
for
Only after regularization, pension will come. For regularization of my
okay.
service.
It just add that for regularization of service as well as for pension after the petitioner was released from service from with effect from
Page 26.
now just give me a date.
Release from service with effect from 30/11/22.
30/11/22.
22. By order dated 15/12/22.
It's okay. Come on, Mr. Vati Jamil, let me counsel for the petitioner, place for some time. That is the court. Matter stands adjourned today. List on when?
Tuesday, next motion.
Okay, make it Tuesday. September 16th, 69.
For motion, item number 37.
May I please, your lordship? My lord, am I audible, my lord?
Yes, yes.
My lord, I am by limited prayer, this repetition is, my lord, by annexure, my lord, 12, the All India Corporation the Indian Oil Corporation has given me time till 25/9/2025 to search out a suitable land for resettlement of my petrol pump, my lord. The problem remains is that, my lord, if I'm earlier occasion also have provided lands to the Indian Oil Corporation, my lord, but those could not materialize because on account of, my lord,
Can we do anything
inviability.
about it? Can we do anything about it?
My lord, the problem remains is that a formal letter, if it is given to us, because, my lord, earlier with whom, my lord, I have executed deeds, my lord, the deeds got cancelled because the recitement, my lord, on account of technical inviability, my lord, those plot of lands were rejected by the IOCL, my lord. So, my lord, if I get a formal letter, then, my lord,
Resetting is something with the court cannot, is beyond our jurisdiction. It will be only the authorities.
so, my lord, in that case, my lord, my limited prayer is that, my lord, I may be allowed to file an appropriate representation before the respondent authorities for seeking a formal letter, my lord, and that may be considered, my lord. If that can be done, my lord.
You do it. Heard Mr. A. Tiwari and counsel for the petitioner who has appeared through video conferencing mode. You will be appearing for the Union of India? For responding one.
My logic, according to the petition, I say that respondent number 2 may not be a necessary party also.
2 would not be transport and highways.
Yes, this transport has nothing to do with.
Nothing to do with this.
Because the stretch which we want to build a RO, it's also within the.
But, my lord, for establishing a petrol pump in the national highway, my lord, the MORTH permission is required, my lord. For that only we have made the respondent number 2 as party, my lord. Ministry of Road and Transport highway permission is required, my lord.
As well as Sri Yangavati and its CEC appearing for the. Your designation is CEC, appearing for the respondent number
1 and 2 then.
1 and 2.
Yes.
Next by the In brief, the case of the petitioner is that they were allotted a retail outlet in a particular plot of land which they possessed as a lesser. However, on completion of the lease period, the landowners did not extend the period of lease, and therefore the retail outlet was closed with effect from
2007, my lord.
2007. Stop. The petitioners project that by letters dated 17/6/2005, requested the Indian Oil Corporation Limited for relocation to another site. It is projected that the petitioner being unable to provide an alternative site by a correspondence dated 29/11/2023, directed the petitioner to appear for personal hearing. And it is projected that the petitioner was allowed time till 25/9/2025 to comply with the recitement, RE-SITEMENT, recitement policy guidelines. Stop. The petitioners have approached this court by filing this writ petition under Article 226 of the Constitution of India for directing the respondent authorities to issue approval letter to the petitioner for recitement of the retail outlet.
My lord, page 46, my lord, the annexure 12, my lord. Last, my lord. Roman paragraph B, my lord. Page 46, my lord. since my lord, the earlier lease deed had to be cancelled, my lord, because we did not get the formal
Just now.
acceptance of the IOCL. my lord.
We are finding something very strange. Something is missing here.
Yes, my lord.
You see, you come to page 41, you say that you have given them a letter dated 7/10/2024,
Yes, my lord.
approval of recitement.
Yes, my lord.
Then you attend a personal hearing,
Yes, my lord.
correct? And in this hearing, there is no reference to your letter.
My lord, the reference, this is what the problem means is that prior to that also, my lord, we have offered lands, my lord, through mails also, my lord, but they have not been responding to us. They are only issuing us so-called notice and
You
personal
went to
hearings,
a
my lord.
hearing, you went to a hearing. Why it is not there in the memorandum?
My lord, we were also
But
surprised.
why in the hearing you would not say that you have already acquired a plot and you are offering an alternative? You are not doing so.
My lord, in that light, my lord, in fact, my lord, we have also executed a deed also lease deed, my lord. But since on
No,
account
no,
of
please don't do. You don't complain against the non-inclusion of your letters in the meeting.
my lord, that I'm extremely sorry because my lord, the petitioners, my lord, they are wife and daughter, my lord.
No, no,
And they are not
something is
under
wrong.
so
You
much-
are hiding something from the court.
No, my lord, I'm not hiding anything, my lord. My lord would kindly see, my lord, I have attended the
See,
personal hearing on 26 June, my lord. Kindly see, my lord.
This is the only question I put to you. This is the only question we have put to you. No
My
other
lord,
question.
my lord, correct, my lord. Maybe, my lord, something is missing, my lord.
No, we are disposing it off. You take your own stand, whatever you want to do.
My lord, what I'm praying is, my lord, if I'm only my representation before the authorities, my lord, because my lord, without a formal letter, my lord, because in Nagaland we cannot purchase land, my lord, we need to take on lease, my lord. So, my lord, if my lord,
It's okay. We have to say something in the order.
so my lord, my only limited or otherwise, my
No,
lord,
you withdraw it without any observation of the court, because if you seek an observation to allow you to make representation, then we'll have to say something.
my lord, I'll withdraw, my lord, with only an opportunity to approach the respondent authority to seek appropriate letters
No,
for.
then we close it. We don't say anything. We don't make any observations of the court. Then you say, so is there. Huh?
My liberty may be granted to approach the authorities, this much, my lord,
Say that
if that can be, my lord.
the Learned counsel for the petitioner seeks to withdraw this petition with liberty to approach the competent respondent authorities on the issue of recitement of the retail outlet. According to the magistrate's dismissal on withdrawal, with liberty to the petitioner to approach the court if occasions arises.
Deeply obliged, your lordship. I'm deeply obliged, your lordship. I'm deeply obliged.
For admission, item number 7.
Next, Lordship. Lordship, I filed my affidavit.
Huh?
I filed my affidavits.
On the last property was given to me. So I have filed it today morning only.
Yesterday.
I regret, I have to take time
Okay.
to find my reply also.
Mr. P. Chaudhary, Learned counsel for the petitioner. Mr. P. Fote,
Lord.
Learned counsel for the respondent,
Lord.
has submitted that today he has filed an affidavit in opposition in the matter. Next, the Learned counsel for the petitioner has submitted that as the copy of affidavit in opposition has been served only today morning, he would like to take instructions and to take appropriate steps or reply if so advised. Or to file reply if so advised. Accordingly, matter stands adjourned today. List on. When do you want, Mr. Chaudhary? 24th of October, okay, 24, 10/20/25. Don't make it 24th, you take one day before or afterwards. Because Friday, we have a very tough time to,
Yes, Lordship.
huh? 27th, okay.
With the Holi, they added the Diwali, that's the problem.
No, we understand, but you see the problem for, at times we have.
When it changes.
Because you see, because I have to go leave early tomorrow, I have a meeting scheduled at the Judicial Academy.
Lord.
Your I have to reach there at 10 o'clock. I have to be there, so I have no alternative but to leave early tomorrow. So if it is one of such days, you'll be traveling unnecessarily.
Lordship, we understand, Lord.
Huh?
We understand.
27/10.
Yes, sir.
Okay.
Interim order to continue.
Okay. Interim order passed first and is extended to the next date.
For admission, item number 8.
Similar order.
Same.
Then some other matter, but the other matter, but I feel it's fine today morning only.
Okay.
I filed this today, Lordship.
Same order.
I will third one to be today morning.
Okay. Same order.
Here also interim order,
Interim order. Okay.
27 can be.
27.
Plus, Lord.
Deep here.
So
For admission, item number 26. May I please, your Lordship?
yes.
Lordship, on behalf of V. Zimomi, Lordship, here he is yet to receive instruction. So kindly grant 3 weeks of time to file affidavit under Education Department, Lordship.
Okay. Both sides are represented. They start to 3 weeks so as to enable the state to file affidavit in opposition in the matter.
Right.
For hearing, item number 44.
So today you will be the Bruce Willis of the court. Last man standing. Yes.
Please, Your Lordship. Your Lordship, here the petitioner is praying for regularization of his service as well as for payment of errors from her initial appointment, that's from 1st September 1994.
The same question to you which we asked in the last case, the motion matter.
Your Lordship,
How
here
is
the
that
petitioner,
permissible?
praying for regularization as per office memorandum dated 13/6/1979, as well as office memorandum dated 17/9.
That relates to compassionate appointment.
Yes, my lord.
Your appointment was under compassionate ground.
Yes, my lord.
Where is the order? Where is the order?
Your Lordship,
Lordship, appointment order annexure 29. The appointment order of the petitioner.
And what is this judgment of this Asino's
yes, my lord.
Sakri? Where is that? You have a copy of that?
It's in annexure 59, page 23. Annexure 23, page 59. Annexure 23.
You had joined when?
Your Lordship, 1st September 1994.
When did your husband die?
Your Lordship, the petitioner's husband died on 12th May 1994.
12 May
1994.
94. Okay.
Yes, my lord. Your Lordship, here the fact of the case is on the demise of the petitioner's husband. Your Lordship, the petitioner was appointed.
When?
The petitioner was appointed on 1st September 1994.
Where is that appointment order?
Appointment order is in Annexure 3,
Annexure 3.
page number 26. Page number 26, Annexure 3. This is the appointment order, approval order. And the appointment order is in Annexure 4, page 28. Your Lordship, here the petitioner had submitted several applications for regularization of his service, as well as for scale of pay, Your Lordship. However, it was not considered. And during the pendency of the case, Your Lordship, the petitioner retired, was superannuated. Your Lordship, the petitioner was superannuated on 31st January 2025.
No, you see, you are not appointed. That's what we wanted to see. You see, you are not appointed on compassionate ground.
Your Lordship,
Because to make your appointment in compassionate ground, there must be some authority who will take a conscious decision of appointing you under the compassionate ground.
yes, my Lord, may I take you to page number 26, Annexure 3.
How we are there?
Your Lordship, here it has been clearly stated that the petitioner was appointed, the petitioner's approval was given.
No, you see, read this letter 20, page 26. Does not say that you were considered for appointment on compassionate ground.
Yes, my Lord. Your Lordship, however, the fact remains the same, Your Lordship.
No, facts change. You see, the government must take a decision on the basis of materials before it. If you are appointed on a compassionate ground, then your appointment orders would have to be routed through the proper channel. And number two, this what do you call?
Your Lordship, in the approval letter, Your Lordship, can you allow me to read, Your Lordship?
Yes, please read.
I am directed to refer to your letter number dated such and such on the above subject approval of the government for appointment of Srimati Sinlole Ringma, wife of, it has been clearly stated, wife of late S. Ringma, and the estate office as contingency sweeper in the fixed fee of rupees 750 till a policy decision is taken by government.
So this is contingency.
Yes, my lord. Yes, my lord. Your lordship, since she was appointed on compassionate humanitarian ground, Your Lordship, it was supposed to be on a regular post, not this contingency. So the petitioner had submitted several applications. Your Lordship, even in Annexure 12, page 43. Annexure 12, page 43. Your Lordship, in this letter, which was submitted by the Executive Engineer, PWD Housing Estate Division, Kohima, to the Chief Engineer, PWD Housing, Nagaland, Kohima. Your Lordship, under the subject, regularization of service. Sir, enclosed, please find your with an application in original received from Srimati Sinlole Ringma, contingency sweeper for regularization of a service. Moreover, I am to state that she was, Your Lordship, I want to make a clear statement here. Moreover, I am to state that she was appointed as contingency sweeper as her husband, late S. Ringma, HA, expired while on duty, Your Lordship. It has been clearly stated that she was appointed.
You see, order of the appointing authority must be a speaking order and everything must contain there only. Order which was appointment order which was passed on 18/8/1994 cannot be clarified in 2001. This executive engineer does not say that he's making statement on the basis of record. And whatsoever, he may have compassion for the petitioner, but that doesn't change the initial appointment order. This appointment order, the government did not rectify it, saying that it was a compassionate appointment. And if it is a compassionate appointment, then all those in that department who were otherwise eligible for being appointed, all the cases has to be considered. It can't be pick and choose. Is it your case that in the PWD, your husband was the only one who expired? So how can somebody be picked and choose and then appointed and then say that this was, and subsequently say, no, it was a compassionate appointment? You see, the order of appointment is by, come to that page again, it is by the Joint Secretary of the Government of Nagaland. Is Executive Engineer PWD competent to say that your order is wrong? In the hierarchy of what you call of the government employees, is he anyone to say to the Joint Secretary order was wrong, it was a compassionate appointment? They are overreaching their authority.
Since the petitioner was aggrieved with this appointment, he had she has submitted several applications for regularization, Your Lordship.
Regularization is same thing we asked for that case.
On compassionate ground, Your Lordship. Since
Compassionate ground, you have this is a subsequent creation.
Your Lordship, in your own office letter, it has been clearly stated here.
Yeah, Lord.
Can I give you a very horrible example?
Yes, ma'am.
It's absolutely horrible. But now you see, I as a single judge, I am passing an order saying that the Constitution bench of the Supreme Court may have taken an erroneous decision. This was the fact was wrongly interpreted by the Supreme Court, and then they arrived at a wrong conclusion. This is one of the most horrible example I can cite. Can I do it? Would I have the competence to do it? That's the first question. Whether it was within the jurisdictional propriety to say that. The authorities could have written to the Joint Secretary saying that you were wrong. We made a proposal for compassionate appointment, and you have given her the contingency sweeper appointment. And I have never found, of course, my experience is not gathered here in the state of Nagaland, it is in the principal seat. I have never seen that a compassionate appointment is made as a contingency sweeper. It must be a post which is in a substantive post.
Yes, ma'am.
A compassionate appointment cannot be made in this contingency.
Your Lordship, the petitioner being aggrieved. She has been submitting application again and again for regularization of a service.
No, but she's asking for regularization.
The fact remains the same, Your
You see,
Lordship.
her position will remain as what? If you apply for, if the petitioner applies for regularization of service, what does it mean? It means that she is perfecting her case as a contingency sweeper and then asking for a regularization of service. She's not asking for changing of a category from a contingency sweeper to one appointed under the compassionate ground. For compassionate ground, you'll have to say that this was a notified vacancy.
Your Lordship, in that case, kindly allow me to receive some instruction from my senior.
Okay. Both sides are represented. The learned counsel for the petitioner submits by referring to Annexure 12 of the writ petition that the petitioner was appointed on compassionate ground. However, the appointment order at Annexure 3 to the writ petition says otherwise. Therefore, when the appointment order dated this is 17th or 18th, page 26.
18th, my lord.
18th.
Yes, ma'am.
Okay. 18/8/1994. Was passed by the Joint Secretary to the Government of Arunachal of Nagaland. Would the Executive Engineer PWD have the competence to mention in Annexure 12 to the writ petition that the appointment was made as the husband of the petitioner had expired while on duty? Explain the Learned Counsel for the petitioner pays for some time to obtain instructions and to address the court. So accordingly, the matter stands adjourned today. List after
2 weeks, ma'am.
2 weeks.
Pledge, madam.
Yes, you're not there. Oh, I am thankful that you are here. Thank you. For this gesture, can I ask you and Mr. Choli to come and have tea with me together? Please. I was comparing you to the famous Bruce Willis. Yes, last man standing. So let me have a cup of tea with you, Mr. Choli.